Hearing is being recorded by HMCTS. You must not make any personal or private recordings or publish any part of this hearing, including court communications. It is an offence to do so. In the Court of Appeal before Lord Justice Lindblom, Lord Justice Baker and Lord Justice Lewis, in the matter of C1 2020 0447, Flynn versus the London Borough of Southwark, and another part heard on Wednesday 17th of March 2021 at 10:30.
Are we all present? Assume we are. I think from the screen I can see that the Constitution is present, and I think I can also see that advocate for all parties are present too. And I see a number of icons at the foot of my screen suggesting that in the virtual portion a number of other people are present as well. And I remind everyone that the proceedings are being live streamed to a very much wider audience. Mr. Kalinsky, overnight we've received some plans. Are you going to introduce those to us?
I'm happy to do so, my lord.
Are they really self-explanatory?
I hope they are self-explanatory. Yeah. I mentioned the outline of Plan W3 and it wasn't visible in the bundle, but you can see it on the ground floor and the upper ground floor versions of those in terms of the location of the commercial units.
Yes. Well, it's much clearer, I think, at this size. So thank you very much, all of you, for providing that. All right. Do you wish to continue?
Thank you very much. My lords will recall that I was dealing with grounds 1 and 2 in the first part of my submissions, and I indicated that there would be 4 stages, and the second stage was just dealing with some factual material. And immediately before the overnight break, I had taken the court to option 3 in the section 106 agreement, and drawn specific attention to the clause there indicating that the payment of the sum was linked to the value of the non-commercial elements. So I'm going to move on from that to deal briefly with option 2, and if the court could just go to that in the section 106 agreement. So it's core bundle, tab C2, page 547.
Yes.
And obviously this needs to be read in conjunction with the definitions of net construction costs, which in turn refers to social rented construction costs. And you were shown those yesterday. We can go to them if we need to for the purpose of analysis. But the point that I would draw attention to is that this is a provision allowing for the payment of construction costs subject to a mechanism for accounting for the value of that which is received, both in terms of the social rented units and the commercial units. And my submission is that that is an entirely acceptable approach to take, the principle being accounting for value of that which is received and netting off against that in terms of the determination of construction costs. So the big picture answer to the case against option 2 is firstly to remind the court that the council has the election between option 2 and option 3. I've explained the rationale behind option 3 and the utility of effectively the big picture accounting mechanism of offsetting the construction costs against the non-residential elements of that. Option 2 provides a different approach in the alternative, and that would be particularly useful if in the 10 years between, if you like, now, when this agreement was entered into, and the need for this clause, construction costs had increased in a way that was disproportionate to value. So it would be cover for that pessimistic and perhaps implausible scenario as an additional option to sit alongside option 3.
Mr. Kalinsky, the case against you is that one part of the case against you is that the word stipulate reduces the scope for this sort of relatively sophisticated calculation of how the costs, of how all this should be covered, and that if this was how it was decided in the negotiations, the matter should be covered, they should have gone back to the members before sanctioning it, because stipulate narrowed the scope for this sort of arrangement.
Well, my Lord, I'm going to come on to deal with that. Let me give you a signpost of what I'm going to say. I'm going to say the word stipulate can only conceivably, on any legal approach, be read in its proper context. And its proper context is a document which authorises the entering into of an agreement within a period of 5 months, contains other provisions relating to that, and is read in the context of its overall provision. But also the second part of the answer is, what is it that is stipulated? It's stipulated that there should be an agreement containing a sufficient sum of money, which begs the question of sufficiency. And my submission, which I'm going to develop, is that accounting for value is a necessary part of determining what is a sufficient sum.
Thank you.
So that's the sort of the big picture answer to where that's going. Now, there is a refinement on this developed orally by Mr. Wolfe in terms of option 2. Didn't feature as I read it in his skeleton to this clause, because the attack on option 2 in his skeleton, paragraphs 30 and 51, is the idea that you need upfront costs rather than costs netted off the value. But he resurrected a point that did feature below, that there was a problem with the precise mechanism, because there was the floor, FLOOR, which he says was a legal floor, FLAW, of the fact that the value was assumed to be set at the appraisal, and it didn't allow for the possibility that in a 10-year period the value might fall. Now, my answer to that is that, assuming we get to the stage of the argument where we're considering what a sufficient sum is, as opposed to there being a point against me in terms of the vires at a purer and prior stage of the argument, then the question must be approached, I would submit, as one of rationality. And my submission is it was entirely rational for this mechanism to proceed on a working assumption that in that 10-year period, values that were likely to rise rather than fall overall, given that it's a decade and nobody contemplated the possibility of them falling. Now, even if the court were concerned about that, and I submit that that's a matter within the judgment of those determining the mechanism for sufficiency, that difficulty doesn't touch option 3, and the council has the choice. So my submission is rationality is the right approach, subject to the prior stages of the arguments, which I will deal with. But if we get to the stage where we're grappling with, does the combination and election between option 2 and option 3 provide a rational framework for determining a sufficient sum? If the court is with me to the proposition that it's lawful to account for value, and that's not precluded by the officer's report in particular, paragraph 364, then this further refinement developed in Mr. Wolfe's oral submissions, I submit, doesn't come close to establishing irrationality in the sense that the court ought to approach that question. Now, part of the context So my submission on context is obviously one needs to think about the word stipulate in the context of the rest of that paragraph, in the context of the rest of the officer's report, in the context of all the practical circumstances and the resolution talking about appropriateness. But part of that context that we haven't necessarily focused on is the legal context provided by Regulation 122 of the SIL regulations. And so I'd just like to show the court that briefly, which is in the authorities bundle at tab 3. And this is the key provision, which, as the court may appreciate already, is also reflected in policy guidance, but this puts it in legal basis, that a planning obligation may only constitute a reason for granting planning permission for the development if the obligation is, and then there's 3 tests, necessary to make the development acceptable in planning terms, directly related to development, and fairly and reasonably related in scale and kind to the development. Now, what's necessary to make the development acceptable in planning terms? My submission is it's the mechanism to ensure delivery is what we're focused on. Does it reasonably relate to the development? Yes. Is it fair and reasonable in scale and kind? Well, a mechanism which effectively gave the council the land, the construction costs up front, and all of the value, I would respectfully say, and this is the way the council thought about it as reflected in our acknowledgements of service, that would go beyond the purpose, because it would not be directly related in scale and kind to the planning objective of securing delivery. Rather, it would confer upon the council a windfall that went too far and did much more than was necessary to secure the delivery. So the whole premise of the argument that you read sufficient sum as full upfront costs with no risk and no account for value, I say, is misconceived, because it runs up against the regulatory restrictions that apply to the council under Regulation 122. Now, the judge, I say, rightly had that in mind when in paragraph 66 he dealt with and dismissed the proposition that 364 was focused on all forward funding and no risk. And I say he's right, because that would go beyond the planning purpose, and it would also, as I've indicated, run contrary to the element C of Regulation 122 of the SIL regulations. So I'm going to move on to deal very briefly with my third step, which is what was the judge's approach. And I'm conscious that the court has in mind the critical passages already from the discussion that took place between my learned friend Mr. Wolfe and the court yesterday. But may I just very briefly offer a couple of observations on that. So if we go to the judgment and looking in relation to ground 1 of the criticisms of the approach, in paragraph 46, the court of the judgment, Mr. Justice Dove is setting out Mansell. Now, as has been observed, he's doing that in the context of an argument which directly put in play the Mansell principles, namely what was ground 1 in the High Court and what became ground 4. So it's an unfair reading of the judgment to say that this is setting up the approach to delegation. This is setting out those principles, and then there is a nod back to them in paragraph 49. But the premise of the written argument, at least advanced by Mr. Wolfe, criticises the judge for construing with reasonable benevolence the scheme of delegation. But the only reference to reasonable benevolence is in 46.2 in the context of the cases of Morge in the Supreme Court, in the context of the general Mansell principles. It's not a concept that he actively deploys in his approach to the scheme of delegation. He doesn't mention reasonable benevolence anywhere else. He does refer back to those principles, but he actually approaches them as part of the context in which the words used need to be properly understood. He doesn't go further than that in terms of, so it's a false dichotomy to say delegation is construed strictly and the judge took a flawed approach by infusing it with reasonable benevolence. My submission is he judged it in the context of the words used having regard to the underlying planning purposes, the practical facts and the well-established function of that document. So it's and this is consistent with the exchange that I think ended up being common ground between my Lord Justice Lewis and Mr. Wolfe yesterday. It's paragraph 49 that we need to look to understand the approach the judge took to delegation. And I would respectfully suggest it can be broken down into 4 steps, and I'll say none of them are wrong and all of them actually are pretty uncontroversial. So the 4 steps I would suggest is to start with the resolution and the concept of what's an appropriate agreement, which, as a judge observes, is a superficially open-ended phrase in the actual resolution. So far, uncontroversial. He doesn't stop there. He embarks in his second step on a process of understanding what appropriate means by reference to the contents of the officer's report. Again, that step is common ground and I hope uncontroversial. But what he does do is he directs himself that it would be wrong to read the officer's report in a way which is inapt as against the established approach to reading those documents. And I say that that must be right because one is looking at the officer's report, the words used in the officer's report in the context of the planning purposes, the function of that document and the use of that document in the particular resolution, which is only to refer to it implicitly rather than explicitly by reference to a particular paragraph. So the third step is to read the report consistent with the principles for dealing with such documents. And the fourth step is to focus on the ambit of the discretion granted by the resolution. That's how the judge frames it in the last sentence. So what that is obviously informed by the officer's report, but the scheme of delegation is the resolution, obviously read in the context of the contents of the officer's report. So my submission is that's straightforward, uncontroversial, and it doesn't break any new ground or establish any new principles in terms of the approach to construction of documents.
Just pausing there before we get to the last sentence. I understand his firstly at the bottom of 124. The next sentence that I wondered what it means.
I'm sorry, we're getting some echo again. I wonder whether we may have to resort to turning off microphones and maybe video as well. I'm sorry about that. But certainly I'm hearing my lord with echo at the moment, and that's quite difficult.
Yes, once is quite enough.
Try again.
Then the sentence beginning secondly at the top of page 125, necessary to consider whether what has been achieved in the obligation amounts to a material and significant departure from the principles of the necessary contributions set out in the committee report, bearing in mind the level of detail. What is that sentence getting at? And what is meant by the principles of the necessary contributions?
So I would suggest that he's asking himself the question based around the resolution of the the superficially open-ended question of what is an appropriate legal agreement, and the content of the officer's report. So the principles of the necessary contributions must be the totality of the officer's report that deals with that, which is the broad headings in paragraph 750, 757, and also the terms of 364. But he's approaching it from saying, they're not saying that this is a, he's not asking himself what precisely is prescribed here. He's saying this is effectively the broad headings of what the obligation is designed to achieve, and I'm asking myself, is there a material departure from those broad headings such that this isn't an appropriate?
It's the words, the principles of the necessary contributions. It's not the necessary contributions, it's the principles. And I'm wondering what the necessary contributions are. Is it the 35% requirement, however it's expressed, for affordable housing? And is the principles of the necessary contributions the tenure split within the 35%?
Yes, although I think I would have to accept that it would cover the concept of deliverability as well, because it's the imposition of the affordable housing together with the right mix of that and the achieving of the delivery of it. Those
so if it went to 25%, that wouldn't be in accordance with the principles of the necessary contributions. But if it was a 50-50 split, social rented and the rest, and for 50 habitable rooms, would that, it wasn't socially rented or socially rented equivalent, would that be caught by what the judge was thinking when he said material significant departure from the principles of the necessary contributions? Is that what he had in mind, perhaps?
Well, I'm gonna have to deal with the detail of that point, which is ground 3 and ground 6 separately. So yeah. Can I come back to that? Yeah. I've spoken about a number of things relating to that, because I don't entirely accept the premise of the way my lord is exploring that with me. So may I come back to that? So anyway, unless there's a further clarification, I was going to move on from paragraph 49 and then just signpost the next stage of what the court, the next stage of what the judge did that's just worth having in mind is the crux of the application comes in paragraph 63 of the judgment. I accept the analysis that the provisions leading up to the paragraphs leading up to that are framing the relevant context by reference to the submissions, and then the point is drawn together in paragraph 63, and the critical focus of the court is to look at whether or not the focusing on the planning purpose of delivery, the council is provided with what it needs in terms of land and provision for cost together with value. So the judge certainly approaches it on the basis of you bring in the concept of accounting for value, and so my argument is dependent upon that being a legitimate approach, but my submission is that is entirely right and entirely within the concept of paragraph 364. Now, if I could just then deal with the contrary analysis, which is Mr. Wolf's submission that the insertion of all value necessarily takes us outside of paragraph 364 of the officer's report. That must be the same point as saying that the only legally permissible way of reading the concept of construction costs is to say we need to have full upfront payment and no account for the value of the land which is conveyed. And that's a rigour that's a necessary part of the case that Mr. Wolf advances for saying that the judge is wrong to add in that concept of all value. And my submission, which I've probably covered the grounds of already, is that that must be wrong for a number of reasons. Firstly, it would take one outside Regulation 122. Secondly, it involves closing one's eyes completely to the practicalities of this being a mixed-use block that needs to be wrestled with somehow in the practical implementation of the principles contained in paragraph 364. And also it moves away from the underlying planning purpose of securing delivery towards a glossed purpose of securing delivery with absolutely no risk or outlay on the part of the council. And I say that's reading far too much into the concept of sufficient sum in paragraph 364. That wasn't what was meant by those terms, and it would be frankly extraordinary if it was, because it would disregard the legal limitations in Regulation 122. So, that being the case, I move to the fourth step of did the judge apply the wrong approach? And again, we've had some of this debate. If I could just draw it back together, my learned friend's approach is derived from the use of the word stipulate, and taking the dictionary definition of stipulate as being something akin to require in an agreement, coupled with his own approach to what it is that's required of sufficient sum being upfront costs with no account for value. Now, I say he's wrong on both of those points, because to take that approach to stipulation involves disregarding the other critical parts of the relevant context, which make it absolutely clear from the report written as a whole that the formulation of the Section 106 hadn't happened yet in precise terms, because it was delegated to officers on the basis of broad heads of terms, and a period of 5 months was given for that agreement to come together. So taking stipulation in that literal sense and removing it from the context, I would submit isn't consistent with any approach to construing any documents at all, let alone an officer's report. And I'll come to Trump in just a moment.
I'm sorry, Mr. Kalinsky, forgive me, but speaking of the negotiation as it unfolded, which you were, is it correct to describe that as a negotiation still fluid at the time of the resolution? In other words, there was a period of effective negotiation up to the point of the committee meeting in July and the resolution. And then the resolution itself explicitly foresaw the continuation of that negotiation for some weeks or months afterwards. So at the point of the resolution, one is, as it were, mid-flow with the negotiation. It was still fluid at that point. Is that a fair characterisation of what happened here?
Yeah, well, that's precisely my submission. That's the context that is well known, because of the, and I say it must be part of the relevant context because of the 5-month period that's allowed. I mean, in fact, the mid-flow is certainly right. If anything, it overemphasises where these things have got to, because they've got to one of the broad heads, but they've definitely not got to how are those broad heads implemented in practice. That is an exercise that necessarily postdates the resolution for a complex scheme, and it certainly did factually in the present case.
Yes. Thank you. I'm sorry, I interrupted a submission.
No, that's very helpful to pin down the way I was putting that, my lord. So I dealt with the stipulate concept, and I think I've already foreshadowed where I am on the approach to sufficiency. So if I could then just deal with the legal basis, because the legal peg that's urged upon the court is the case of Trump. And and I just wonder if I could just go to that shortly, because it might just be worth looking at what Trump establishes and doesn't. I'm going to take this shortly, unless it's helpful to be more expansive about it, but it's tab 9 of the bundle of authorities, and the two paragraphs that my learned friend Mr. Wolfe referred to were paragraph 34 from the speech of the judgment of Lord Hodge, and paragraph 66 from Lord Carnworth. If I just try to make this point by reference to paragraph 34 of Lord Hodge. So standing back from this for a moment, the factual context of Trump is the construction of a consent under the Electricity Act of 1989, which is obviously to be treated from the reasoning as being broadly analogous with the approach to a planning permission. And the thrust of the reasoning is that you take account in so construing of the words used and their context, and that there isn't a completely different set of legal principles for approaching a planning permission from approaching another legal document. Now, my submission in relation to this is twofold. Firstly, it doesn't follow from Trump that that's the approach you take to an officer's report, because Trump is dealing with an instrument that confers status in and of itself. So I would concede that perhaps the resolution would be informed by a Trump-style construction, but it would be a step further than the Supreme Court went, or any court has gone, to say that the Trump principles are the governing approach for an officer's report generally, or in the circumstances here where there's only an indirect reference to the officer's report through the concept of the understanding of what's appropriate. So as a matter of legal approach, I don't accept that the principles in Trump displace Mansell. That's the first point. But the second point is, even that might be a completely academic debate, because what are those principles? Well, those principles are, if I just pick it up from paragraph 34 of Lord Hodge, it's an objective exercise in understanding what's said, having regard to the natural and ordinary meaning of the relevant words, the overall purpose of the consent, any other conditions which cast light on the purpose of the relevant use, and common sense. So it's not as if it creates a meaningful dichotomy between an approach of reading, say, an officer's report, having regard not just to the words used, but the context and purpose of the document, other parts of that document, and applying common sense. So if you were to finesse the Trump-style approach to construction, taking account of the context of an officer's report, I would respectfully submit you'd end up pretty much in the place that you are in any event under Mansell. So I don't accept Trump applies, but actually to say it's Trump on one hand and Mansell on the other, and the judge was wrong to apply Mansell, just creates a meaningless dichotomy, because Trump is all about reading words in their proper context and in a purposive way. So that's all I wanted to say about the so-called construction debate. The other legal peg of my learned friend's case is Carlton Conway, and I mean, to be fair to him, he puts it very lightly on the basis of Carlton Conway. He accepted correctly that Carlton Conway covers a different type of delegation. It's a scheme of delegation that never comes to committee, and the only positive proposition he sought to draw from Carlton Conway was the single line in paragraph 21 of Carlton Conway that said, where powers are delegated to a single individual, the scopes of those powers must be carefully considered. Well, I mean, that's not a proposition that I want to or need to dissent from, but it begs the question, the critical question, what are the relevant provisions dealing with the scope of delegation. And that's the resolution, the concept of an appropriate legal agreement. So if we're going to go into these type of cases, and I don't hesitate to do so, but I just want to just suggest this briefly, that a better proxy for that might be the sister case of Carlton Conway, which is the Springhall case that was you were taken to very briefly, which is at tab forgive me, tab 6. And I don't want to overplay this point at all, but it's conceivable that this might help slightly. So can I just show you Springhall? It's a case that is a Court of Appeal case. It comes after Carlton Conway, and it was concerning the extent to which Carlton Conway created a restrictive approach to the construction of schemes of delegation. And the outcome of this was to distinguish the circumstances of Carlton Conway and to apply a particular approach to the scheme of delegation in this case that was different. So if I just show you the relevant scheme of delegation, this is an officer's delegation case, but if we go to paragraph 9 of the judgment, it's the judgment of Lord Justice Old giving the judgment of the court. So in paragraph 8 and 9, the scheme of the delegation is set out, and the relevant bit is the issue is defined, I think, sufficiently in paragraph 9. The question is whether, having regard to the terms of the guidance and the circumstances, forgive me, it was treated as being within the delegated authority under Roman 4. And the relevant bit of Roman 4 was that the application are in accordance with any supplementary planning guidance. And the context of this, which I'll show the court briefly, although I don't want to get too bogged down into it, was there was a debate about whether demolition of a building where there was a presumption against demolition, but you could demolish it consistent with other parts of the policy, was contrary to could rationally be in accordance with the supplementary planning guidance. So that's what lies behind the framing of the issue in paragraph 9. The question is whether, having regard to the terms of the guidance and the circumstances of the case, it was open to him, meaning the delegated officer, to conclude that the proposal accorded with the council's supplementary planning guidance, in particular its presumption against the demolition of building designated under its provisions as of townscape merit. So the key point is the terms of delegation created a concept of, is the scheme in accordance with the supplementary planning guidance? And the approach that's important here is the court approached that as an exercise in planning judgment for the delegated officer, and it rejected the idea that Carlton Conway called for a different or more restrictive approach to that. So just picking up the relevant bits of the judgment on that to the extent that they are capable of assisting. If I pick it up at paragraph 28 of the judgment, there's reference to Carlton Conway at the start of paragraph 28, and then reference to Mr. Justice Richards, the judge below in Springhall, and the court says Mr. Justice Richards held rightly, in my view, that Carlton Conway does not compel the same result in the present case, where there's no uncertainty about the applicable policies and the facts to which they are applied, and where it's plain that the officer had both well in mind in deciding whether to decide the matter for himself and grant approval. And then it's then picked up in paragraph 30 that this is essentially a matter of planning judgment as to whether there's compliance with the supplementary planning guidance. and that's discussed in detail in paragraph 30. And then the kind of the ratio of the court, the ratio of this judgment, I think, can pick up from paragraph 32. In my view, it is for the local planning authorities to determine the policy or basis of their schemes of delegation, not for courts to gloss them by imposing fetters on them according to the court's own perception of how decision making should be allocated between committee and officer. And that's in the context of the proposition that there was necessarily a restrictive approach that was applied through Carlton Conway, and that's dealt with in terms in paragraph 33, because Lord Justice Auld says in paragraph 33, if I pick it up halfway through, if and to the extent that Lord Justice Hill contemplated in paragraph 25 of his judgment that some special modified Wednesbury rule should apply to the question of vires of an officer purportedly exercising such jurisdiction in planning matters as distinct from the conventional Wednesbury irrationality or other legality of the decision itself, I respectfully disagree. So the reason I'm drawing that to the attention of the court is the context in Carlton Conway was, in Carlton Conway it was scheme of delegation about agreed policies, completely unclear how it was applied. In Springhorn it was scheme of delegation that turns on whether it's in accordance with the supplementary planning guidance. The approach of the court is, well, that's a matter of judgment for the planning officer, and to reject the idea that there's a heightened Wednesbury test to be applied. So, and then there's the passage that you've already seen about the competing approaches to delegation, pulling in different ways. There's participation on the one hand and efficiency on the other. But then Lord Justice Auld confines Carlton Conway as making sense in the context of the case itself, but not applying a stricter approach. So my submission is that's actually a helpful clue as to how this court might want to consider approaching the concept of appropriate. Appropriate necessarily involves a value judgment as to what's appropriate. Of course, that has to be informed by the contents of the officer's report, but when you go to the contents of the officer's report, you find another term that requires a value judgment, that of sufficiency. And who answers those value judgments and how? Well, just because they're in a scheme of delegation, it doesn't stop them being matters that the officers need to address themselves, exercising judgment. And here you've got an absolutely clear trail that the officers did consider sufficiency in terms of option 2 and option 3, because the drafting of option 3 was absolutely nailed down by reference to the terms of 364 of the officer's report. So that takes us, I respectfully submit, to the formulation that my Lord Justice Lindblom offered in argument to Mr. Wolfe of the question being resolved of, are the options read together in light of the option being conferred as an effective way of delivering affordable housing? Was that a rational judgment on the part of the officers, having regard to the question of sufficiency being a matter that's not fixed in absolute terms, but is capable of requiring an analysis of accounting for the value of that which is transferred? So, my lord, that's the legal approach to ground 1. And I say the judge got all of that right, and that there's no novel approach, and thought when one thinks about the terms of the delegation in the present case, they all point in a similar direction. In terms of ground 2, I think I've covered the ground already. The basic proposition is the combination of options is within the concept of 364. That's a matter of judgment for the officers. We know what their outcome was because they took pains to expressly link back the wording of option 3 to paragraph 364 and properly understood that was an appropriate agreement within the meaning of sufficient sum. Paragraph 364 approached in a sensible way that takes account of both the words used and the context in which those words are used and the context of the location of the units within the broader scheme, and also the context of the fact that it was obvious that the negotiations were still ongoing in relation to the Section 106 from the 5-month period that was afforded and from the consultation provision. Now, just finally, so I don't accept it's a Kiddy's case, and I don't accept the criticisms of unworkability or lack of precision that are advanced in the written arguments and part of the claimant. It clearly is open to a council to be more prescriptive, more precise. It would do so through its resolution. If it would be open to the members to put much closer reins on officers as to what was an appropriate agreement. They could do it through a resolution. They could elect to supervise closely the precise basis of the agreement. But my submission is that isn't what they did here. They trusted their professional officers to come up with a workable and approach that was consistent with the broad principles. And that's an unsurprising approach for a scheme of the complexity of this, because it's inherently unlikely that the planning committee would have the capacity to micromanage the terms of the Section 106 obligation. And I make submissions to that effect in paragraph 52 of my written argument, but I don't think I need to detain the court by developing those further. So I propose, unless there are any questions I haven't already addressed, move on to grounds 3 and 6.
Just pause and make sure my colleagues do not have questions. No.
Thank you very much. So I'm now moving on in the argument to the fallback position of the build for sale on the west side. So the situation in which this arises is the east side has been built out in accordance with the build for rent basic proposition, but the developer has elected to indicate that rather than go down the primary means of continuing with the build for rent proposition, an alternative approach is going to be taken on the west side. And we need to look and understand what the 106 provides in relation to that and compare it to what was authorised. So I'm going to focus on what was authorised and then come to what the Section 106 provides and explain why what was provided was consistent with what was authorised.
Which ground, just remind me?
I'm sorry, we're on ground 3 in relation to the general vires, and then this then comes into ground 6 as well in relation to the social rented equivalent point.
If you could, just at least for my benefit, flag when you have reached ground 6 so that I can write in my notebook ground 6.
Yeah, these two are linked, but I'll deal with them separately, so that should be very clear, my lord. So ground 3, so the references in the officer's report are actually common to both. And I just want to take, there's 4 references that I want to take up in relation to the officer's report. We're in the supplementary bundle. The officer's report is in tab 2, and just for your note, I've summarised these in paragraph 57 of my skeleton, but I'm going to take the court to the passages in turn. So the first one is paragraph 365 of the officer's report on page 127 of the bundle. And so this refers to the applicant also wishes to retain a fallback position whereby the west side could be delivered as traditional build-to-sell units. The exception to this would be the social rented units in the mansion blocks, which would be delivered in any event. The developer would notify the council of the intention to develop the west side as build-to-sell, and the affordable housing requirement for this would be 50% social rented and 50% intermediate. Some of the west side social rented units would already be secured in the mansion blocks, albeit at 38 rather than 50% requirement. Therefore, a review mechanism would be required. So it's contemplating the existence of an option, that option, if exercised, triggering a change to approach to mix. And how is this going to be addressed? It's going to be addressed through a review mechanism. We then get to the provision dealing with the review mechanism, which is at page 132, paragraph 404. I'm going to come back to 403 to deal with a different stage of the argument, but in terms of just mapping out the vires of the build for sale provisions, it's 404 that we need to look to. So in the event the west site is delivered as open market for sale, the review will need to, and this is what it says, take into account the policy requirement for a different tenure split of 50-50 social rent and intermediate. So it's the review mechanism going to consider and take account of that different requirement, i.e. different from the tenure mix that would otherwise apply if it was billed for rent. And I'll come to explain precisely what that means. But for present purposes, it's again signalling this will be resolved through the review mechanism. What's the review mechanism? It's a viability review mechanism that will consider how to take account of the different split requirement that relates to the build for sale units. So that's that provision. And then there's a little bit more detail in the addendum reports. So we need to just look briefly at both addendums. So addendum 1, passage to the court, hasn't been shown yet. At paragraph 16 of the addendum 1. That is on page 247. And as the judge noted in paragraph 21 of his judgment, it was common ground below that there was a typographical error in this paragraph. So I'll show you how it should be read, but this was common ground in the court below. So the heading there at 16 is viability of build to sell scheme on the west side. The applicant's revised affordable offer includes a fallback position where the units on the west side could be delivered as build to sell. Viability information has been submitted to appraise this option, which has been reviewed by GVA, those are the viability consultants appointed by the council, on behalf of the council. GVA have advised that at present, that means the build to sell alternative, would be less viable than the proposed, and that build to sell should be build to rent. So in other words, the changed proposition of build to sell in the present economic conditions is less viable than the base case of build to rent.
Right, so in the fifth line of that paragraph, build to sell should have read build to rent.
That's exactly right. That's the only correction that's needed, and that was common ground, that was what was intended and how it should be read. And it then says, and a review mechanism would be required. I do emphasise these words, to capture any uplift in value. So the situation is, we've got to, if we go down this fallback position, we've got to think about a different approach to tenure mix for that part of the scheme that's been built out separately. How are we going to do this thinking? We're going to do it in the context of a viability review. At the moment, the viability situation is worse, but that doesn't mean we shouldn't have a review provision. We will have a review provision, and we will capture any uplift in value at the time. And then finally, we've got an exchange in addendum 2 in relation to this, which is at 256.
Yeah.
So Mr. Wolf's clients, or at least the group of which Mr. Flynn is a member of the 35% group, were complaining that the committee cannot reach a decision on the application if the applicant will not commit to build to rent or build to sell on the west side, as the affordable housing requirements are different. So positive assertion that the affordable housing requirements are different, and a complaint that the tenant should nail their colours to the mast. How's this responded to? Well, right at the foot of the page, I can pick it up from in the last line. Addendum Report 1 considers viability for a build to sell scenario on the west side, which would be a fallback in any event, and the social rented units would be protected. So that's the paragraph 16 that we've just been looking at. The proposal and clear intention is to develop the west side for PRS, that's the build to rent, but has indicated a possible, if unlikely, scenario whereby it would be developed for sale. This would trigger, this is the advice members are given, a slightly different affordable housing requirement. The 106 agreement will set out how this would be addressed should it arise and ensure that the requisite affordable housing provision would be secured. The committee is entitled to consider the application on this basis. So drawing those threads together, the key points are SP6 is the mixed policy for the build for sell. That's billed as being different from the mix that would otherwise apply. It will be applied if this scenario arises through the mechanism of the value to capture any uplift in value, the detail of which, despite complaints to the contrary, would be left to the section 106 to work through. So that's the context. Would it be helpful just to remind the court briefly of what the provisions are of the 106 before I deal with my case on this? So I think I can deal with this pretty shortly. So we're in Core Bundle Volume 2, and we're in Schedule 3. If we start at page 551, top of page 551, you've got, if you like, the election between the scenarios, the normal scenario, build to rent or build to sale. So that's the trigger at 6.1, basically. These are obligations on the developer to notify the council whether open market build to rent units will be provided as open market build to rent or open market for sale units. So that's the election provision, and then the operative provision in terms of the obligation to provide extra units is contained in page 562, and Mr. Wolf shows you this.
Yes.
The operative provision, which comes into effect if viability review 3 has gone through, and I can show you those provisions, but this is just the operative effect that triggers the obligation. So if following viability review 3, it's determined that additional affordable housing is required, the developer shall deliver the additional affordable housing in accordance with the provisions of this schedule. So that's an obligation to deliver the additional affordable housing following viability review 3 if that determines that there is capacity for the additional affordable housing. Now, the definition of additional affordable housing in the agreement as it was originally formulated was defective because it didn't refer to the additional units, but that deficiency was caught by the deed of variation the court will see it, at the back of Core Bundle 2. And that's at 365, the operative provision. So the amended and perfected drafting provides that the last bullet point there, where the West site provides open market for sale units up to a maximum of 15 additional social rent equivalent habitable rooms to be provided on the West site, and a commensurate decrease in the number of intermediate housing habitable rooms. So
I haven't got that reference. You said 365. I can't find 365.
I'm so sorry.
I've gone to the deed of variation, which is at 678.
Thank you. I'm so sorry.
He wants to go to the deed of variation.
I gave you the wrong reference. 685. 685.
Right.
So
685. Yeah.
It's clause 2.1, and it's the third and last bullet point there. So that's so the combination of 4.6 that I showed you on 562, read together with this provision that provides for that, is how this comes into effect. So
I've got it. Sorry about that, yeah.
No, entirely my fault for my brain, and that says something different to what my brain meant.
It's the third bullet point.
Yes, so yes, up to 15. So the legal issues here are what's the scope of the restrictions conferred by in the committee report properly understood. Now, I've taken you through those provisions. They refer to it being an application of SP6, the 50-50 mix, done through the prism of a viability review assessment, but the detail of this to be left to the Section 106 agreement. Now, the complaint, as I had understood it before Mr. Wolfe made his submissions in relation to ground 3, was that the ground should have secured a 10-year split of 50-50. That's how it's put in writing. And the answer to that is that it does. And I'll explain why it does. But it does so, albeit subject to an adjustment that's self-evidently necessary and viability that's expressly contemplated by the terms of the report. But it absolutely does apply policy SP6 50-50 split. How does it do that? Well, the most convenient place of trying to explain this is I hope, paragraph 62 of my skeleton argument, where I've tried to set this out in one hopefully coherent explanation.
You want to look? Shall we look at that?
It'd be helpful to have that available.
Are we putting the Section 106 agreement away now?
I think you can. Yes. Yes, I think you can.
Right. So your skeleton argument now.
Do you need a page reference for that, or you?
At the moment, I just need to find it.
Sorry.
I've got it.
So, and it's paragraph 62 and 63 is actually where the detail is.
Yeah.
So the proposition in 62 reflects what I just said. A 50% mix is applied to the build to sell housing once you've done a process of attributing social rented housing, excluding social rented housing attributable to the east side in a way that I say is contemplated by the officer's report. So how was this worked through? And that's paragraph 63. If I could just try to follow this through, and then I'll deal with the case against it. So in this, and I'll just say, this is based upon the emails that are disclosed at Core Bundle page 312. and 313, and this is all discussed by the judge at paragraph 69 and 70. But the basic steps to understand are, firstly, what's the scenario that gives rise to this? So we've got the west side is developed for build to sell, and on the west side there are in total 1,754 habitable rooms, and those are physically located in two types of accommodation. 1,304 of them are in the towers, and 450 of those are in the mansion blocks. That's basically the whole of W3 is the mansion blocks. So in the scenario that we're concerned with, the east site has already been built out for build for rent housing. And that consisted of 1,604 habitable rooms broken down by tenure type. But the critical point is, of course, no social rented was delivered, because the whole scheme was that all of the social rented would be delivered on the west side. So of the social rented that's going to come forward now on the west side, a proportion of that is properly attributable to the development that's already taken place on the east side. And there's an exercise in making a judgment as to how, in this hybrid situation, you properly account for that. Now, the way that it was done was, and this is referenced in the documents, was to say what's happened on the east side was build for rent accommodation. There's a specific policy, albeit emerging, P4, that deals with build to rent. So I'm going to take an attribution of the social rented that's referable to that type of housing, and I'm going to ring fence it as owed to the east side, and then I'm going to apply the 50-50 tenure split to everything else. And that's, so it's to the everything else that the SP6 50-50 tenure split is applied. The only prior step to that is the ring fencing of the 192 habitable rooms, forgive me, because they are, if you like, in colloquial terms, owed to the east side, because what's come forward on the east side doesn't include the necessary components of social rented accommodation. And then you then plug, having made that adjustment and having worked out the requirements of the tenure, of the 50-50 tenure split, you end up with 15 units, 15 habitable rooms that you can't fit into the mansion block. So this is the 15 habitable room overspill, and that's where the 15 figure comes. And there's two elements. Ground 3 is the wrong approach being applied, and now there's a challenge to the 15. I'll deal with both of those points. And then also there's the equivalent point, which is ground 6, which I'll deal with separately. But does the court follow how the 15 habitable rooms comes about and how it relates to the application of policy SP6 to the build to sell proposition once an adjustment is made to ring fence that part of the social rented accommodation that's being built out that's properly referable to the obligations owed by reference to the development that's already taken place on the east side.
I think the answer to the question you put to the court, Mr. Kalinsky, is that if we read and grasp paragraph 63 of your skeleton argument, the answer is in the affirmative.
Yes, I'm grateful. And then if I just relate that to what the judge did, if we go to paragraph 70 of the judgment.
Yeah.
He describes the ring fencing in his own way in paragraph 69. So paragraph 69 broadly equates to paragraph 63 in my skeleton. And then he says this: whilst the claimant contests the ring fencing of 192 habitable rooms, leading to a greater shortfall in habitable rooms to be required in the fallback scenario, I'm entirely satisfied that the approach taken and the calculation which I have set out above is entirely rational and appropriate. It flows from the acknowledgement that some of the east site social rented units were to be provided in any event on the west site and could not therefore be properly attributable to the west site itself as an affordable housing requirement. Once that is understood, the calculation is perfectly coherent. Furthermore, it's entirely consistent with the material contained in the officer's report. So the key thought is, once you've made the ring fencing adjustments, it's uncontentious that they're applying 50-50 to there, and the judge is saying the ring fencing adjustment is entirely rational and coherent in the particular circumstances of this hybrid development, which relates to this fallback scenario, the detail of which would be worked out through the Section 106 agreement. So the broad proposition is what we did in the Section 106 agreement, as amended by the deed of variation, is entirely consistent with the indication in the officer's report. The detail will be worked out, but we will be applying the 50-50 from SP6 subject to viability and through the viability mechanism, and that's why you end up with up to 15 habitable rooms. So that's the positive case that I advance. Now, I need to deal with what Mr. Wolfe submitted to you, which involves, I'm afraid, taking one step backwards to understand where he starts his argument, because my submission is he started his argument from an entirely incorrect place, namely the proposition that, that there was something remiss about thinking about policy P4 in this context. And I just wanted to explain why that's the wrong starting point and then deal with his argument to the extent that I haven't already covered it. So I need to go back to the officer's report in the supplementary bundle. And you may recall that he sorry, let me just check the reference. Yeah, so you may recall that I won't take this up, you may recall he went to the recital of the viability appraisal in the 106, and he was critical of the fact it referred to policy P4, and he then took you to page 125 of the supplementary bundle, where the comment is made about the weight of emerging policy at 357. It said, this policy is a material consideration, although it currently has limited weight. And he said that we're using P4 to work out the contribution, but that contradicts the basis on which the committee decided it because they had placed little weight on it. See paragraph 357 of the committee report. Now, that is an incomplete analysis of the officer's report and its approach and the relevance of P4, reading that paragraph in isolation. And I'll deal with this shortly, but it is potentially an important point for understanding why his argument goes off on the wrong basis. So you'll recall that all of the policies are laid out, and we've got to keep in mind the distinction between a development plan policy and an emerging policy. So we've got development plan policies, London Plan 312, part of the development plan, broad imperative for maximum reasonable affordable housing. You've got the Southwark core strategy policy, which read together with the saved plan is where the 50-50 mix that applied clearly to the build to sell as a different tenure mix in paragraph 404 of the officer's report that we've been to. And then we've got P4, which is not part of the development plan because it's emerging policy. policy, so limited weight in terms of how far it's travelled, but it's the only policy that condescends to the build to rent proposition. So when you look at the way it was analysed, it wasn't left out of account at all, but it did feature quite closely in the analysis in the officer's report, and it's that which I want to show you. So,
can I make, before you do that, this is a relatively trivial request, but it would help me at least to have the proper titles of each of these plan documents, because they're referred to as the core strategy and the emerging plan and so forth. I would, for my part, like to know exactly what they are properly called, these plan documents, so that they can be accurately referred to in our judgments.
Of course. Well, can we see to that?
It's just, I'm sorry, it's just a detail, but I haven't so far managed to isolate it in the papers.
Of course. Thank you. So this P4 is a new Southwark plan.
Yeah.
355. But we'll give you that note, my lord.
Yeah.
Is it okay after? Shortly
Of
after?
course. Yes. No. Absolutely. I just thought I'd mention it now, since we're looking at different policy documents.
I just want to I don't want to take too long on this, but I just want to show the court this, because it does affect where Mr. Wolf's argument starts from. So you've got the range of those policies, and then you've got a broad assessment of what's proposed in the primary scenario against all of those policies. So, for example, if you just look at paragraph 361, you'll see quite clearly that the proposition is analysed both against SP6 and against P4. So the P4 requirements are for a much higher proportion of London living rents than discount market rents, and the proposal is weighed against that. So do you see, comparing the 52% in the P4, so that's paragraph 361, second row, final column, is the requirement, and what's actually provided is much lower than that, because what happened was there was a prioritisation of the social rented, and there was a slight under-provision of those other elements, and all of that was analysed in the planning analysis which follows. And in the planning analysis, at, for example, 388 on page 130, the proposal is analysed against, amongst other things, emerging policy P4. And in terms of understanding the structure of the report, the analysis up to and including 389 is about mix viewed independently of viability, which is why the conclusions are expressed at 389 as being subject to considerations of viability. And then in the section that follows, you see the heading viability, and you get the taking account of viability, which I'll come to. But just to understand the structure of this, you then go over the page at 134, page number, paragraph 415, which you haven't yet seen, but there's a heading conclusion on affordable housing. And this is where the strands are drawn together in relation to mix and viability. And it says the proposal is for a new form of affordable housing, which has not previously been provided in Southwark. However, it's a form of affordable provision which is being recognised as making a useful contribution to addressing housing need, notwithstanding the extent to which the affordable housing provision is contrary to some elements of the development plan, notably the core strategy. Officers are satisfied that the provision as revised is the maximum reasonable and that it's in overall conformity with the development plan, taking account of viability. So that's expressed clearly in terms of the judgment as to London Plan Policy 312, because that's where the maximum reasonable affordable housing concept comes from. And it's absolutely clear when you read this fairly and as a whole that an analysis of emerging policy P4 and how it fares in terms of mix and any justification in viability terms for under-delivering on the P4 mix is part of the judgment which informs that conclusion expressed in 415. So that's the overall context of the analysis. Now, why does this matter? Because with that insight in mind, let's go back to the viability review heading. Now, you'll recall that we were concerned with 404, which is the viability review for the build for sale viaries, and that's absolutely the most direct provision. But it's not the only viability review in play. There's the general viability review that's mostly dealing with the build to rent scenario. And what does that provide? Well, that's dealt with at 403 in terms of the viaries, and it says this: as with any development of this nature, a viability review will be triggered in the event the development has not substantially commenced within 36 months of the grant of planning permission. This is 12 months longer than the norm to allow for extended clearance and preparatory works that a scheme of this scale entails. In these circumstances, 36 months is considered to be justified. There will be a post-implementation review for each site to be undertaken at 75% occupancy. And this is the bit that matters. Any uplift at 50% to the council would be applied to adjust rent levels downwards towards meeting the distribution set out in emerging policy B4. So for the build for rent scenario, the whole of the viability review is directed to improving compliance with policy B4. And you can see why there's a need to improve that compliance if it can be justified viably. If you go back to 361 and just look at the shortfall, not in relation to social rent, but in relation to the London living rent, which is the slightly less accessible, but still mid-tier accessibility one that we haven't been concerned with. But there's an under provision of that, and the general viability reviews are not about increasing social rented, they're about improving the affordability of the other elements by express reference to policy P4. So with that thought in mind, let's go back to Mr. Wolf's submissions. Mr. Wolf's submissions is, why on earth is the council thinking about policy P4? It should be thinking about policy SP6. To which the answer is, you need to think about both. You need to think about how to attribute the element of affordable housing that's owed to the east side. How better to do that than use the policy that's specific to the type of tenure concerned and around which the whole of the rest of the viability mechanism in the agreement is structured. Once you've done that, you knock off the 192 habitable rooms, and to the balance, you apply SP6. It's absolutely foursquare within the analysis in the officer's report. So the criticism of the use of P4 falls away. The criticism of the number falls away. I'll deal with the alternate put forward by Mr. Wolf closely, but actually the whole analytical framework for this is rationality of, is this a rational way to apply a complex fusion of two types of tenure in a mechanism that was said to be left to the viability review, the detail of which was going to be worked out in the Section 106 agreement. Now, my submission is the answer.
Can I just copy that to make sure I understood? So one of Mr. Wolf's complaints was you've got one development, east-west. Why are you using PS4 for the east and SP6, whatever it is, for the west? And your short answer is because they each have different tenures on them. East has build for rent. This is west on a fallback scenario, which would be build for sale. You do stage one, you take the P4 when you're calculating the amount of housing on a build for rent site, and you get a figure. And then when you turn to the east, when you turn to the west, you simply take out of that the figure that you've already calculated, and then you apply to that part of the development, that policy which applies to the tenure on that part of the development. Is it as simple as that?
Yes, it is, and that's entirely consistent with 403 and 404, because 403 general policy review is environmental structured around P4, and there's a different tenure split, different from what? Different from P4 that applies to the west side. So it's all within the binaries that's obviously there within the report. So my lord has it. That obviously what you the intellectual proposition that depends upon is that you do an accounting exercise for what's owed to the east side, but that's self-evident on the basis that the whole structure of the scheme was that the social rent attributable to that would be provided on the west side, so it would be wholly flawed not to make that adjustment. So, my lord, that's exactly right. Now, I hesitate to deal with it because...
And that answers the cap as well, doesn't it? Because the cap is just the mathematical consequence of the working out of the two things you've done. One, you're going to make an attribution, and two, you're going to calculate it by using that policy applicable to that part of the development. And that's the figure of 15 rooms.
My lord...
I think I've got it. I'm sure my colleagues got it yesterday, but I've got it now.
And then the only other point that was dealt with orally, and I hesitate to go there because it's not in this little skeleton at all, but he resurrected his High Court proposition that the right answer was 49 rather than 15. Now, the bigger picture legal answer to that is rationality, matter for the planning officers, see paragraph 70 of the judgment. But there's actually an obvious problem with the, and so, I mean, that's my primary submission, but my secondary submission, without taking too long over this, is that if you go to page 166 of the core bundle, which is behind tab B1.
Sorry, which page?
166.
Yeah. Is it, sorry, in the core bundle, yeah.
Yes, I think so, yeah. it talks about the 3-year term with tenant only, and then the position at the end of the term, and it says the tenant whose income after 3 years has taken them into either a higher or lower household income may wish to stay in the same apartment. No tenant will be asked to move from an apartment other than where they wish to do so. So there is actually a safeguard of individual tenants in the scheme that's proposed, and the interested party explained that to the court below in its written submissions, which I'll give you the reference to in a moment, but it's made good by the terms of this document. So the key difference between the two concepts is the social rented.
But what is the legal status of this document? I understand your argument that you look at it from the point of view of providing enough houses, but if at the end of 3 years the tenant and the partner had got high incomes or had won the lottery, what's to stop the developer saying, well, I'm sorry, you can't stay here anymore?
I think the answer to that is it would have to be tied down in the Section 106 obligation. And
yes.
Can I, without going into the detail of that, can I just refer the court to, there's a note 256 that was put in by the interested party, and this point is covered at Section 3 of that note, and the analysis is put forward as to how that is given effect to. So the answer is paragraphs 8.3 and 8.4 of Schedule 3 of the Section 106 agreement, see 3.4 of this.
Okay, thanks.
The key distinction is social rented accommodation is provided either by the council or a registered social landlord. Social rented equivalent is provided and managed by the developer, but subject to the conditions relating to rent, tenure and management secured in the Section 106 agreements. Now,
rent, tenure and management.
Yes, and it being secured through perpetuity. Now, on the detail of that, I defer to but rely upon the written submissions that Mr. Harris put forward in the court below, which is at 256 to 258, which the judge accepted to the extent that he said, well, there might be nuanced differences, but they're not material in terms of this number of social rented accommodation. There's protection, there's a significant amount of protection in terms of rent levels and security of tenure that is comparable, or is designed to be comparable to social rented accommodation, subject to the precise nature of the individual tenancy, but there are safeguards to protect the individual tenants, as I just explained, and the rent levels are broadly comparable, but the key difference is who's managing that. Now, in terms of why are we looking at social rented equivalent rather than social rented? Well, the explanation for that is the one that's set out in the Council's acknowledgement of service. So if I could ask the court to turn forward in the bundle to B10 at page 304A. The answer, in short, is simple practicalities. So, as is explained here, these additional 5 habitable rooms must be provided outside the mansion blocks on the west side. A registered provider would not want to take on a number of social rented units within a much larger tower block that also contain private units due to the complexity of management arrangements which would arise. The only realistic position is that the 15 habitable rooms would be provided as social rented equivalents and would be managed by the developer together with the other units. So it's all about the fact that the 116 units are within that management block that's entirely self-contained. It's capable of being managed as an entity by a registered social landlord. But when you've got this, if you like, unbudgeted for overspill, then you're not going to make that an attractive proposition to a registered social landlord. So the next best thing, having regard to the purpose of the policy, is to provide it as social rented equivalent. That's the simple explanation. Now, the submission is in the context of the whole of the scheme, the small nature of this, that is within the scope of the authority conferred by those provisions of the officer's report, which did not condescend to detail, but envisaged that there would be an accounting mechanism for the slightly different approach to tenure split, the detail of which is to be worked out in the Section 106 agreement. In that context, my submission is the judge took a sensible and practical approach to say that these differences were nuanced rather than material or critical in terms of this small number of additional housing. Now, I accept that members were exercised about social rented in relation to the main provision, but that's a wholly different order of magnitude to wrapping up these additional units in a way that makes sense in the context of the physical footprint of the developments, the detail of which was left to officers to work through. So I say, on a sensible and practical approach to the vires, the nature of these are not ultra vires. The flexibility that was conferred to give effect to the principles, but to do so in a way that was workable.
Just remind me, if you would, which paragraph in the judge's judgment?
It's so ground 6 is dealt with at the end of the judgment, and he sets out the criticism. He sets out the submissions at 71, and then he expresses the view that the differences are not material in 72. He said, yeah, there may be nuanced differences, and they'll be managed in different ways. But the important point was that the officer's report was a review in terms of affordable housing and whether the additional habitable rooms were to be provided as social rents for social rents equivalent was not identified as being in any way a critical point, which the delegation to the officers of authority to enter into the 106 obligation turned.
Can I just make sure that I've understood this? Because in one sense, the details don't matter. The first question is, could you depart from a strict 50-50 social rented split? And your answer to that is, firstly, there's nothing equivalent to the stipulate a particular solution. And secondly, that the way in which you get to the 15 extra rooms arises because it's switched to build to sell. And that's contemplated by a viability review, the details of which are going to be put into the 106 agreement, but there is nothing, you say, even remotely equivalent to the level of alleged prescription in the paragraph 364 when you get to this particular working out of a particular scenario. Is that the way to understand it? And then you go on to say, and in practice, there's not much difference anyway.
That's it. That is right. My learned friend would say that, if you like, there's an implied stipulate in paragraph 365 of the officer's report, but I don't accept that, and I say you've got to read 365 together with 404 and the flexibility expressly conferred by the two addendum reports.
Well, you say you've got to look at it as a whole, and it does start off by saying the developer would notify and the affordable housing requirement for this would be 50% social rented. Some of the west side socially rented units would be in the mansion blocks, and a review mechanism would be required. And you say you can't read the first part of the stipulation without reading the second part, presumably, in your case.
Yeah.
And then the review mechanism for the 15 rooms can alter the social rented requirement. And you say, in practice, it's a rational conclusion here because you say the differences are not so significant.
Yes, my Lord, absolutely right. On any view, 365 takes you into the review mechanism, and the review mechanism is expressed as officers can work this through. We're satisfied we can leave this to officers. It's said in terms. in particular in the addendum report too, when there was an objection made that this should all be bottomed out precisely before the committee, and the committee's view was no, we can leave this level of detail to the officers, and in that context, saying that the 15 habitable rooms it seems very far-fetched in my submission. So that's ground 6, and I can then move to the final pair of grounds 4 and 5. So unless I've just paused, are there any questions before I move on from that in relation to the 106? So
grounds 4 and 5 then.
So grounds 4 and 5. So this is the this, just to orientate ourselves in where we are on this. This is the proposition that there was either an error of fact or significantly misleading advice in Mansell terms in the way in which grant funding was dealt with in the officer's report read together with the addenda. I've set out the key references to this in my skeleton at paragraph 67. You'll recall that there's paragraph 371 of the main officer's report that referred to grant being recently confirmed. That was the main focus of the challenge in the arguments in the court below. And the proposition was, well, actually, when you go to the addendum report, you see it explained and qualified in terms of an agreement in principle. And then, in particular, there's some exchanges in the addendum report at paragraph 22 and 23, which deal expressly with whether the grant funding had been secured and what significance that had for the delivery of the social rented accommodation. So the overview answer is that when you read those provisions together sensibly, you're not on the wrong side of Mansell, you're not close to being on the wrong side of Mansell, there's no error of fact. Before I develop that, can I go to I won't, unless the court wants me to, revisit 371, but I do want to go to the first addendum just to look at paragraph 22 of the first addendum report and 23. So that's in the supplementary bundle, tab 2, page 248. It might be interesting just to revisit the reported submissions made by the 35% campaign to which this comments. So the first bullet point there is to welcome additional social rented units, but affordable housing tenure split does not comply with the core strategy or emerging policy P4. Now, welcoming the 116 is a good start in terms of the addition, but also it's interesting that what's the reference to the split in terms of P4? Well, that can only be not about social renting, but about the other components in terms of the London living rents, which is covered in the viability. And then they say, well, having welcomed the addition of the social rented units, we want confirmation that this will be delivered even if grant funding could not be secured. And the answer is, well, there's agreement in principle to grant funding, and there's a commitment to providing the level of affordable housing set out in the latest offer. So they asked for an assurance that the affordable housing would be delivered irrespective of the grant, and they got it in terms and unequivocally. So that's the main answer to the suggestion there's an error of fact or misleading. Now, I say the essence of the advice was grant is available, that's absolutely right. Read as a whole, there was no suggestion that it was actually secured, and I'd understood Mr. Wolfe to accept that in exchanges with the court earlier. The focus of the objection was, well, will there be a commitment to deliver these units, to which the answer on any view is yes, and implicit in that is who's bearing the risk of this grant not materialising. It's the interested party, and that's absolutely plain from the facts properly understood, and the court will probably have in mind already that the viability base case assumed in the agreement assumed that grant would be provided. So if grant wasn't provided, then they just it would have it wouldn't change what they were providing, but it would have an impact on making it less viable, but they would still be obliged to deliver what was actually being provided. So the case has now pivoted to this idea that there is a material difference between agreements in principle and eligibility welcoming a bid. Now, it's really about levels of abstraction, having regard to what the purpose of this point was in the context. I'm sure it's right that you could drill down what is meant by the concept of agreement in principle and reach a more precise analysis that what that means is you're within the terms of the type of scheme we would provide grant for, but we welcome an application. You'll need to show us you've got planning permission as part of the conditions of that application. I mean, that's where the detail is. But in the context of how this features in the analysis, the only thing that matters is, will the social housing be delivered, or is it dependent upon the grant? And the point, that's how the council were analysing it, that's how the claimant was analysing it in the objection that it made. I'm happy you're going to give us more social rented, but are we going to get it irrespective of the grant? Yes, we've committed unconditionally to deliver it. That was the way this featured in the decision-making process. So against that context, my submission is the ground just falls away. It plainly isn't significantly misleading. It plainly isn't an error of fact. And you don't get to the discretion argument, but the thrust of the point, which is relevant both to ground 4, whether it's material, and ground 5, discretion, is, you know, where could this conceivably go? Well, the way it's deployed is to say, well, if they were willing to give us 116 with the grant not in the bag, then why stop there? Why not push harder and get more? Well, the answer to that on the face of the planning policies and on the face of the planning analysis in the officer's report is that there is no sustainable basis in policy for seeking a higher level of affordable housing than that which can be justified in viability terms. That was the basis of the expert advice that the council was given. It's the basis of the planning analysis that was set out in the report. And it's simply misconceived to say that you should expect members to have pushed harder and harder without there being any policy basis, when the evidence is that in January they were specifically advised that there would be a high risk of this being unsuccessful on appeal if they were pushing a viability position that they couldn't substantiate on the basis of expert advice. So,
isn't it simpler, Mr. Klinsky, if they weren't misled and yet they weren't legally able to get the grant, thereafter is for the councillors to decide, what do we do next? Do we stay at 116? Or do we think there's scope for manoeuvre? If they weren't misled, how they reacted to the advice is a matter for them, isn't it?
Well, no, that's exactly right. You don't get past the threshold question of was there misleading advice. It has to obviously be significantly misleading or demonstrable error of fact. Now, my submission is absolutely simply, you never get past that. You're dancing on the head of a pin to start differentiating between agreements in principle and eligible, but we're not at the stage of actually determining the application, which is the way it's put in the context where what really matters is how many social rented units are going to come forward from this scheme. So, my lord, I entirely agree with the proposition that you never get beyond that because there's nothing in play. And I say unnecessarily, but it's relevant to the discretion argument and to whether it's a material error, that it would be a significant hostage to fortune to chase a viability case that wasn't being substantiated in the light of the material that was before there and which the committee accepted from other parts of the report that were set out in black and white and haven't been challenged. So that at a canter is the response to ground 4. Ground 5 raises a question of discretion that doesn't arise on the judge's primary analysis, and consistent with my exchange with Lord Justice Lewis just a moment ago, I say similarly doesn't arise. Mr. Wolfe takes the court to the Plan B case and also in written argument to Powys. We don't get to this point, but my submission for what it's worth is that both of those cases are cases where there is, if you like, a complete failure to have regard to either a statutory duty in the case of Powys or an important consideration on the Court of Appeals analysis in Plan B that was fundamentally game-changing in terms of the analysis. And in either of those contexts, the court needs to be incredibly careful about filling a vacuum. There's no vacuum here because viability, we know what the policies mean, we know what the expert advice was in terms of viability, and we know what members concluded about viability because they're taken to follow the officer's report absent an indication to the contrary. So for all of those reasons, there's a complete disconnect between the alleged error, which isn't an error anyway, and the alleged lack of evidence as to what would happen, because there's no error, and also there's no vacuum, because we know precisely how questions of viability were approached in the context of this decision. So I'm happy to develop that further. I also note that the Plan B decision, I'm not quite sure. I don't know part of my case to try and quibble with anything that's in that. I just sound a note of caution that obviously that case went to the Supreme Court, it was overturned, and the Supreme Court, I think, had a ground of appeal that related to the approach to discretion that they felt was unnecessary to deal with because it didn't arise in the circumstances of that. So whilst insofar as that draws together principles that are clear from elsewhere, like Powys, no quibble at all, I just throw some caution as to whether that's the right foundation for basing any decision on discretion. But the broader point is...
The Supreme Court did not engage with that proposition in the Court of Appeals judgment in the Heathrow case. From memory, I think that's right.
That's right. I think I looked at this, my lord, and I hope I got this right, that I think it did feature in the grounds of appeal, but they expressly said it was unnecessary to deal with it. Yeah.
So it's left without their endorsement and without their criticism.
Exactly.
I think is the correct position.
Yes. Yes. But my broader submission is we're just in a completely different category to the filling a vacuum case. So, my lord, I've dealt with 4 and 5 relatively shortly, but I think that's the essence of the submissions in relation to those. In my skeleton, I put down the sort of a marker for the need for thought and care if one gets to relief. I've put that in paragraphs 90 to 95 of my skeleton. I think it's difficult to develop these submissions in the abstract from any determination, but I think the key marker is if and in so far as in relation to the build to sale there's any concern about the legality, I would say that's entirely severable and could be dealt with through amendment to the section 106. I also would make that same submission, although the process of correcting might be slightly more convoluted in relation to the securing delivery in relation to grounds 1 and 2.
Well, I think for my part, I would prefer that you don't make submissions on unknown hypotheses. We discouraged Mr. Wolfe from doing that, and I think we'd invite you to hold any session for the appropriate moment, if and when it arises.
I'm entirely content to take that approach, and I'm grateful.
And I should, if it helps Mr. Harris, I shall probably say the same, subject, of course, to my colleagues agreeing with me when we come to his submissions.
So I think I've reached the end. May I just take a moment
of course, yes, please.
Any instructions on anything that my clients would like me to cover? If I just take a moment.
Yes, of course. Please take your time.
Thank you very much. My Lord, I think it's safe to proceed on the basis that there's nothing further for those behind me. So unless I can assist in any of those are my submissions.
Those behind you electronically. Thank you very much.
Thank you.
Just make sure my colleagues don't have questions. I should have asked them.
No, thank you. Thank you very much, Mr. Kalinsky.
Thank you, Mr. Klinsky. Yes, Mr. Harris.
Many pleased, Your Lordship. Mr. Kalinsky has left me very little to do. I produced a speaking note which has got shorter as his submissions got longer, which I've asked to be sent to you. Hopefully it will be helpful, and from it you'll see that I have a little to say about grounds 1 and 2, largely because they raise issues of perhaps more general importance. But very little.
Is that on its way by email to us?
It is, my Lord, yes.
Do you want us to wait until it comes through? Has it been sent to our clerks, or how's it come?
It's been sent to the clerks.
Yeah, let me just
very recently.
I'll just go to the inbox and see what's there. It's not come through to my inbox yet.
Well, I assume it's being sent to us at the same time, but again, nothing here.
Correct, and apologies.
What is it now? 12:36. Do you want us to wait for that and read it? I mean, what we could do, although it's a little early, we could stop now for the short adjournment, and then we shall all have had a fair opportunity to read your note before you address us, or you can address us now if you would prefer to do that.
I suggest the first option is the better option, and it may mean that I don't have to read very much, if any, of the note in any event.
That's what I thought.
Questions on it.
It might save some time overall if we did that.
Yes.
Well, look, let's do that. Let's stop now. 12:37. We'll come back. We're comfortably going to finish today. I think even need to add a question mark to that.
Correct.
Sentence. So we can come back, I think, at let's come back at 1:40 to resume. Right, 1:40 to resume. Thank you very much. We're adjourned now to 1:40.
Russell, are you still there? You're muted.
I am, David, yes. I'm just trying to find out what's happened to it.
I say no sign of any emails, and normally they come through pretty swiftly. So
yes, they do. Just bear with me.
Of course.
David, do you want me to send it to you direct?
That would be very helpful. Thank you very much. Cut out however many middle people there are.
Although I'm not
and to Sarah Stackman, if you can do that.
Yes, of course I will. Yeah.
Yeah.
So,
No worries. Let me see something. Russell, are you still there?
Give it to you for some reason, so I've sent it to Sarah.
Oh, you said it's
I asked her to forward it to you immediately.
Okay. Okay, that's fine.
I must have the wrong email address for you, but I've been trying. Just had an email back from her. She's got it. So.
Okay, that's super. Okay, that's fine.
Yeah, I'm sending it to you now, David.
Okay.
Russell, can I get it as well? It's Dan.
Dan,
Yeah.
I'll send it to you.
Okay, perfect. Cheers. Thanks.
Okay, sorry, chaps. I don't know what's happening there.